and get started. Thank you for indulging our lateness a little bit. You never know what's going to happen on the House floor on any given day, so surprise, surprise. So here we are. We'll go ahead and get started with approval of minutes. Those were sent out for January 24th, 26th, 27th, 31, and February 1st. Were there any questions on those? And if not, do I have a motion? Representative Smith. Okay, move to approve. Do I have a second? Representative Howerton. All in favor of approving the minutes, say aye. Aye. Any opposed? All right, minutes are approved. All right, we have got 5 bills we want to go ahead and work today. It's taken us a few days to get to this point because of cancellations and everything else, but we're going to start with final action on House Bill 2516 and ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2516 would require an offender who raises an error in their criminal history calculation for the first time on appeal to show prejudicial error. It would also require the journal entries used to establish that criminal history to be attached to the criminal history worksheet, and it would authorize the court to correct an illegal sentence while a direct appeal is pending.
All right, thank you very much. Any questions for Natalie? Representative Wheeler.
Thank you, Mr. Chair. In context of this bill, the meaning of prejudicial error, it would seem to me that if the juvenile presents a journal entry of adjudication of guilt, that in itself is considered prejudicial error. And it seems like there's 2 standards in this, and I just want to make sure that I'm not misunderstanding it.
Natalie, any thoughts on that?
Mr. Chairman, I would point in the bill on page 3, line 37. That's where we're talking about. And I just want to clarify: we're not really talking about juveniles here. We're talking about adults who are challenging their criminal history calculation after they've been convicted and sentenced, and then they're saying, "Hey, actually, my sentence should have been different because my criminal history was different." And so the wording there says that if an offender raises a challenge to an offender's criminal history for the first time on appeal, then the offender has the burden of designating a record that would show prejudicial error. So if the sentence would have been the same either way, then they're going to have a hard time showing that the fact that journal entry, for example, that was used to calculate their criminal history wasn't attached to the worksheet. If their sentence would have been the same without that conviction or with that conviction, then that's what they're going to have to show, is that there was some type of error that was prejudicial to them because their criminal history was miscalculated.
Thank you. In other words, we could have a conviction, and forgive me for the juvenile part, conviction that didn't change the grid box at all. Is that what you're saying? Thank you very much.
Thank you. Representative Carmichael, you have a question?
I do, Mr. Chairman, and I don't know if it's appropriately for the reviser, but perhaps you all can help me out. Isn't this the bill where Clayton Perkins, on behalf of the defense lawyers, testified they had worked out a compromise, and that I think he testified as a proponent? I don't know if anyone recalls, but I'm trying to refresh my memory.
He was a proponent. Go ahead. If you have that in front of you, Natalie, go for it.
Mr. Chairman, you'll recall, and this got brought up during the hearing, but this was a bill that was introduced last year on behalf of the Attorney General's office, and the defense bar did come in with opponent testimony at that time, and then Clayton Perkins with the defense bar and Natalie Chalmers with the Attorney General's office worked on a compromise together, and what you have before you now is the result of that compromise, and they did both testify in favor of the bill.
Ms. Scott, you were extremely helpful.
Yes.
That's exactly what I remembered now.
Thank goodness. Thank you, Natalie. All right, committee, any other questions? All right, seeing none, what's the will of the committee on this bill? Cool. Thank you.
Mr. Chair, I'll make the motion to pass HB 2516 favorably for passage.
Thank you. All right, Representative Smith offered that motion, and Representative Patton seconded that motion. Committee, any further discussion on this bill? All right, seeing none. Representative Smith, we'll let you close.
I moved my amendment and close. I moved my motion. How about that? Now I close.
Thank you. That's right, exactly.
got what I could get.
All right. Thank you, committee. All members in favor of moving this out favorably, say aye.
Aye.
Any opposed by the same sign? Very good. We got that one passed.
May I have my
Representative, you didn't even give me time. Representative Carmichael would like his vote cast in the affirmative. Recorded, yes, in the affirmative. Anybody else? All right, thank you. Moving on to House Bill 2517, we will ask Natalie to give us an update on 2517.
Thank you, Mr. Chairman. House Bill 2517 would transfer the responsibility to certify the drug abuse treatment providers that participate in the Certified Drug Abuse Treatment Program. We usually call that Senate Bill 123 treatment. It would transfer that responsibility of certifying them from the Department of Corrections to the Kansas Sentencing Commission. And I can take any questions.
Very good. Committee, any questions? All right. If not, looking back on this, if I recall, Natalie, it was Scott Schultz and he wanted to take that over from KDOC, if I recall correctly. He was the only one that testified on it.
That is correct. And if actually, I think if maybe we could wait a second for Representative Heiberger to sit down, we might want to do that if possible.
Certainly, we'll do so. Oh, it is your understanding that you have an amendment? Okay, very good.
I will send that to Colette.
Thank you, yes. We'll go ahead and get that sent out. It appears that Natalie just has all of our backs today, so thank you for that. Yeah, forward it to the group.
Understandable.
Yes, yes. Exactly. We are looking for, we're like for you to make your motion on your amendment and explain it while it's being distributed. Hold on a second. Natalie's saying no. No, normally we do the amendments first and then we move the bill.
Mr. Chairman, I have an amendment that I
Care to
don't,
share your amendment, Representative Heiberger?
it applies, this, it's a technical amendment. The new section on SB 123 for diversions has some of the same language that we're amending in the current statute. It just applies that to it as well. Did I get that right, Natalie?
Yes, Mr. Chairman, Representative Heiberger, you will recall that in Scott Schultz's testimony, he mentioned that we overlooked making the same change in the new Senate Bill 123 treatment, the new version of that for diversion. So you'll see here on the attachment down in subsection F, there's just a reference to that Certified Drug Abuse Treatment Program and saying that they've been certified by the Secretary of Corrections to treat those persons pursuant to KSA 7552-144. This bill changes 7552-144 to change that reference from the Secretary to the Sentencing Commission. So this is just a technical fix to clean up that reference.
Thank you. Thank you for that. Any questions for Representative Heiberger? All right, seeing none, you may close. Oh, I'm sorry. Representative Patton, second. We're going to get all this sorted out. See, we're all discombobulated today because we rushed up here to get started.
I move my amendment.
We'll find our groove. Thank you. Thank you. All in favor of Representative Heiberger's amendment, say aye.
Aye.
Any opposed by the same sign? Very good. And we know that Representative Carmichael wants to be mentioned in the affirmative.
Oh, not necessarily, Mr. Chairman. On small procedural amendments, it's not necessary, but I'm happy to have it there.
Well, hey, we're going to go with it for consistency, as does Representative Heiberger. Excellent. Now, we probably need to move the motion. Did we have a motion on this bill? Okay, there we go. We have an amended bill. Can I get a motion?
Mr. Chair, I move that the committee report HB 2517 favorably for passage.
Very good.
Second.
All right, Representative Keither, seconds, and Representative Heiberger first. Committee, any discussion? All right, seeing none, you may close.
I move my motion. Thank you.
Thank you very much. Members, everybody in favor of moving HB 2517 out favorably as amended, say aye.
Aye.
Any opposed by the same sign? And we have Representative Carmichael and Representative Heiberger in the affirmative. All right, moving on to the next one, House Bill 2471. 2471. Committee, are there any, do you want Natalie, give us an overview. Let's start there.
Mr. Chairman, House Bill 2471 would prohibit the use of restraints during hearings under the revised Juvenile Justice Code, and it would also authorize exceptions to that rule if the court holds a hearing and makes certain findings on the record.
Very good. Committee, any amendments on that bill? Do I have a motion on this bill?
Mr. Chair, I have a motion.
Go ahead, Representative Smith.
I have a number of misgivings. I'd like to table this bill.
All right, we have a motion to table. Do we have a second? All right, Representative French is the second on that. Committee, discussion. Representative Heiberger.
Thank you, Mr. Chair. I mean, I understand that there are some members have concerns, but I was swayed by the testimony of the, I believe it's the testimony from the GALT or Commission or GALT agency about how their experience with this in another jurisdiction, I believe it was Florida, where they saw no increase in bad incidents and actually had some positive results. So it's my understanding that one member might have a potential amendment that might address some concerns. So before we table it, maybe we might give a chance for that member to see if he will offer an amendment or not.
Do we have an amendment from a member that wants to share that? Representative Carmichael.
Mr. Chairman, I actually do not intend to offer the amendment that I had drafted and that I had shared with you and others. But I would like to mention, I think that the GALT Institute or the study that they did was actually specific to Kansas, and it's about a 20-page study or more, as I recall. So I think their suggestions were based more on, were based specifically on what about 20 different observers saw in courts in Kansas. So I just wanted to pass that along, and I might be incorrect.
All right. Thank you, Representative. Representative Heiberger.
Yeah, Representative, I believe that the study that was referenced was from Kansas, but the testimony of the representative who testified, my understanding was that she testified that they'd also worked in Florida, and she talked about their work there where they had positive results.
Mr. Chairman, I think that is accurate. I appreciate that.
Certainly. Any other discussion, committee? Representative Smith.
Mr. Chair, I would just point out, part of my misgivings are on the testimony given by the GALT representative, and it was, frankly, the fact that they were not willing to divulge any specifics of where it was seen, how it was seen, what it involved, specifics that were extremely important in my mind, and decisions on whether to restrain individual who's in court. I mean, those individual circumstances need to be discussed. If a court is misusing their authority or ignoring the liberties of people, that needs to be addressed. And we have processes in place for that to give them a blanket legislation as if that is somehow going to change the court's prerogative. I don't think that answers the question. I think there are other ways to do it, and that's why I want to table the bill.
And members, for our newer members, just so you know, a motion to table effectively kills the bill for the year, just so everybody understands that. Any other discussion? All right, committee. Oh, no, Representative Osman.
Thank you, Mr. Chairman. I I understand the trepidation with the testimony that was presented itself, but in my mind, the testimony itself is only ancillary to the question of what the bill specifically is and what it's designed to do. And in my mind, what they saw or didn't see or what is or isn't in the report is irrelevant. The question becomes, is it appropriate to have restraints for use during a hearing? And we can get into that larger discussion, but my answer is no, it's not appropriate. And this is a good rectification of these issues. So, for me, I could get into all the specifics as to why. I mean, we really talk about, in one of the pieces of testimony, they talked about 3 different people chained up together. That is a serious consequence of not being able to speak directly to your attorney and have a proper attorney-client privilege. Just that alone should sway what we should do in a court of law. So in my mind, I wish to have this bill debated and proceed as regular. Sorry, thank you.
Any other discussion, committee? All right, seeing none, we have a motion to table. Would you like to close, Representative Smith? You had a second. French seconded you.
All right, very good. Just wanted to make sure. I close.
Thank you. Members, on the motion to table, all in favor of tabling House Bill 2471, say aye. Aye. All opposed, say no.
No.
Ayes appear to have it. Ayes do have it. Representative Heiberger wishes for his no vote to be recorded, and Representative Carmichael wishes for his aye vote to be recorded. Very good. Thank you, committee. Moving on to House Bill 2515. Natalie, would you give us an overview, please?
Thank you, Mr. Chairman. House Bill 2515 would create a mechanism to seek relief from the Kansas Offender Registration Act requirements for drug offenders, and it would also allow expungement of those offenses when that relief is granted.
Excellent. Committee, questions for the reviser? Seeing none. Committee, do I have or hear a motion on House Bill 2515? Representative Heiberger.
Mr. Chair, I move that the committee report HB 2515 favorably for passage.
Very good. Do I have a second? Do I have a second?
Second.
Representative Howell. Very good. Committee, are there any amendments on House Bill 2515? Hearing none. Any discussion on House Bill 2515? She gave it. You want to give it again?
Mr. Chairman, House Bill 2515 would create a mechanism to seek relief from the Kansas offender registration requirements that would only apply to drug offenders. And then if that relief was granted, the offender would then be able to petition for expungement for those offenses.
Very good. Yep. Any discussion? Representative Heiberger.
Thank you, Mr. Chair. I think this is a relatively moderate bill. I mean, it gives people who've had drug offenses put on the registry, if they had clean records for 5 years, to have an off-ramp. And we've heard a lot of testimony over the last 2 years about how important it is to have an off-ramp for people on our offender registry. I mean, even if we pass this bill, we'll still have one of the most restrictive, broad offender registries in the country. So I really hope the committee could support this one small step to help people who've paid their time, come clean, and are wanting to get their lives back together. Just give them one little bit of help.
Representative Smith.
Thank you, Mr. Chair, and I would agree with the representative on that idea. One of my greater concerns is once it leaves this committee that there will be attempts to change the nature of what the bill does, frankly, because there are strong opinions about, and on either side, I'm sure you're aware, strong opinions on either side about how much further we should go with that idea. But certainly an off-ramp is something that I think, most folks can understand needs to be addressed. When people are doing the right thing, you need to give them the ability to get back in the right, and I'm not against that. I just have fears of attempts to make amendments once it leaves this committee, so I just wanted to voice that.
Understood. Representative Carmichael.
Thank you, Mr. Chairman, and I certainly am cognizant of the Vice Chair's concerns. But, I think a strong, unified vote from this committee might go a long ways to keep that from happening. Thank you.
I appreciate that, and I tend to agree. The 3 years I've sat on this committee, this being the fourth, we have always talked about the offender registries, and we've always talked about, in many ways, how ineffective they are, how Kansas has more than anybody else. And so part of the attempt of, I'm actually the one that requested this bill to be drafted this way, was to narrow it down, was to make it something that is attainable, because I think in the past we have tried to just take such big bites out of the apple that there were concerns, and that's why I never made it across the House floor. So this is an attempt to take, as Representative Heiberger mentioned, a step in the right direction to allow people that are put on a 15-year registry, if they have turned their life around, to go in front of a judge after 5 years and request for that release to occur. So appreciate that. And is there any other discussion, committee? Oh, Representative Keither.
Thank you, Mr. Chair. I would kind of like to agree with everybody that's spoken to this. I understand the Vice Chair's concerns as well, but I think this is a step in the right direction as well. And again, we in this committee have always had a strong joint, big voice together. And I think if we can get behind this and fight hard with whatever they throw at us on the floor, it's something that needs to go forward. And I would certainly want to support this. Thank you, Mr. Chair.
Absolutely. Thank you, Representative. Anybody else? Representative Howell.
I just want to say that I support this bill because I think it's very well written. It has very good balance for, and Natalie, correct me if I'm wrong and I say anything incorrect, but it's my understanding that once they apply to get off-boarded, they have to go to court and make their case in front of a judge. There's good checks and balances here. We don't need to have people going to our jails because they failed to file the correct paperwork. We don't have the money to spend on those kinds of cases. And there is nothing more appropriate as Americans as when someone served their time and they're making the right steps to changing their lives, that we don't give them a way to expunge their record and, and be able to live their life without crippling paperwork, as this seems to be the way it is currently. So I think this has a very good balance of all those factors. So.
Thank you. Any others? Representative Keither, is your hand back up again, or did we not get it down?
Sorry, I thought I took it down.
No problem. All right, committee. Let's see. Representative Heiberger, I don't see anybody else. We'll go ahead and have you close.
Thank you, Mr. Chair. I would renew my motion that the committee recommend House Bill HB 2515 favorably for passage.
Thank you very much. Committee, all in favor, say aye.
Aye.
All opposed? No. All right. Very good. Representative Carmichael and Representative Heiberger are in the affirmative. All right. Last one on the list is House Bill 2200. Natalie, would you give us an overview of House Bill 2200, please?
Mr. Chairman, House Bill 2200 would allow the evidence-based programs account money to be used on certain children who have been assessed as according to the assessment agreed upon by the Department of Corrections and the Department for Children and Families as having possible criminogenic behavior. It would also require the Department of Corrections to build data systems and allow for the overall case length limit extensions for certain juvenile offenders in order to complete an evidence-based program.
Very good. Committee questions for the reviser? Seeing none, I do have a technical amendment on this bill. I'll go ahead and ask Natalie to distribute that. The technical amendment, if you guys will recall, this is a bill that was introduced last year And by working it this year, there are a number of dates that have to change and things that are just of a technical nature within this bill. So go ahead.
I would add to that, Mr. Chairman. Typically with these carryover bills, we do have supplemental references that need updated from 2020 to 2021. I would note there are a few deadlines in this bill. The bill requires the Department of Corrections to report to you at the beginning of, it would have been this last legislative session. It also requires them to enter into a memorandum of understanding by a particular date. So this amendment also pushes all those dates back a year. So that's a little bit more of a policy question, in case you guys did want to discuss that.
Very good. Any questions, committee? All right, I will make the motion on my amendment. Do I have a second? I'll second. All right, Representative Smith, additional questions or comments? Seeing none, I close on my amendment. All in favor, say aye. Aye. Any opposed by the same sign? Very good. Technical amendment passes. I know of, I believe, a couple of other amendments out there. So who else has an amendment for me? Representative Howerton.
Thank you, Mr. Chair. My amendment would be, I guess on page 6, section 4H, I believe it's line number 38, to change the 45 days to 90 days.
Okay. Natalie, do you have that amendment? Want to get that sent out to everyone for their review? And all that does is, as I understand it, extend at the judge's discretion, the case length limit from 45 days to 90 days. Is that correct? Oh, go ahead.
Mr. Chairman, it's actually the cumulative detention.
Detention days, my apologies, not case length limits. The cumulative detention days from 45 to 90. Very good. Has that been distributed? Okay. Want to wait for that to happen? Yes, certainly. Let me get a. All right, so Representative Howerton made the motion for the amendment. Do I have a second? Representative Smith is our second. Committee discussion or questions? Representative Heiberger.
Revise the question, if I may. The current bill says that the term of detention shall not exceed the overall case length limit. So if there was a case after this amendment was passed, that was a 45-day limit, then this section would not change the limit of detention to 45 days. Is that accurate?
Mr. Chairman, Representative Heiberger, correct. So the law currently, we have probation length limits and we have overall case length limits. And then this cumulative detention limit that's currently 45 days is essentially over the entire time of that juvenile's case. They can spend no more than 45 days in detention over that entire period. If someone's overall case length limit were about to run up, this 90-day change wouldn't override that. So they would still be bound by that overall case length limit. But over the course of the entire case, the judge would be able to utilize 90 days of detention.
In the case of someone who, at the judge's discretion, had a 45-day case limit, then the detention limit would be 45 days still, or no?
Yeah, so none of the overall case length limits are that short, but if they were, say they were running up against their overall case length limit, say they were 50 days away from it, and the judge wanted to sanction this juvenile to detention, they would only be able to sanction that juvenile to 50 days of detention, even though technically 90 days, they'd still have time on their cumulative detention length, but because they're running up against that overall case length limit, that would be the end. Unless, of course, because this bill does allow for extension of the overall case length limit if it's for the purpose of finishing an evidence-based program.
Okay. All right, thank you. Representative Keither.
Thank you, Mr. Chair. Could the maker of the amendment explain why she's bringing it?
Certainly.
Thank you.
Thank you, Mr. Chair. I just heard from a lot of the proponents for that, that we listened to and read in the testimony, that there just wasn't sufficient time and they needed extra time sometimes. For some cases, not all of them, and I want to allow them the time that they need.
Thank you. Any additional questions? Representative Howard, Representative Howard, and you may close. Oh, sorry, you have another question, Representative Howard?
It's a comment. I mean, I'm not sure whether it goes to the underlying bill or to this, but I think it might go to both. So I don't know if you all got the email that was sent out earlier today about the information I'd asked for about adult convictions and juvenile convictions over the last 5 years in Kansas. And if I'm looking at these, and I mean, we heard testimony that I thought the Sheriff Salcido was referring to 45-day case limits. He may have been referring to detention limits, but the overall impression from our conferees, the proponents, was that things were just gotten completely out of hand in the juvenile world. But I look at these statistics that were provided by research, and I see an increase of violent crime for adults from 2016 to 2020 of 13.7%, and an increase in violent crime by juveniles for 7.3%. There's a big jump in 2017, but none of SB 367 went into effect until the middle of 2017, and all of it didn't go into effect there. In fact, there was a large decrease from 2019 to 2020. So I guess the evidence, I don't think, supports the idea that there's a vast increase in juvenile crime because of SB 367. So that's why I would be reluctant to tinker with it at this point.
All right, thank you. Any additional questions or comments, committee? Now I think we're ready for you to close, Representative Howard.
Mr. Chair, my hand is up.
All right, sorry about that. Go ahead, Representative Carmichael.
Not a problem. I actually moved to my real office so that my hand wouldn't blend in with the woodwork and my fake background, just to try to help the chair.
Well, part of my problem is my additional screen has died on me, and so I'm trying to balance all this with one screen. So sorry about that.
Not a problem at all. I appreciate Representative Heiberger refreshing my recollection concerning the testimony of my old friend, Deputy Chief Salcido, who I think, as I may have mentioned when he testified, he was our community police officer for many years in the area known as North Riverside. So I respect the man and I like him and we're friends. But for several years at community meetings and other locations, my friend, in my judgment, had overstated the extent of the difficulties with juveniles that he believes arose out of reforms that we undertook some years ago. And I had asked him for more than just anecdotal reports. I'd really asked him for some data, and he did retrieve some information from the police department's records. And I read it. And I have to confess to you, I didn't have time to call my old friend back up and try to explain to him that I couldn't prove his case from what he sent me. But when I look at what Representative Heiberger obtained through research from the KBI, it confirms my qualitative impression that the case may well have been overstated. And so while it may not be directly with reference to whether it's 45 or 90 days, I just haven't found this evidence to be persuasive. And so I'm going to have a hard time supporting an extension of time as reflected in the amendment, but probably a much harder time, frankly, in supporting this legislation. Thank you for hearing me out.
Thank you. Anyone else? Hold on, I'm going to check for hands, more hands. Representative Howell.
As my children will testify and you will all get to know, I am very fond of the word balance. And even though I think it's very possible that the need for these kinds of amendments and adjustments maybe for a smaller fraction of these juveniles. I think the allowing the parties such as the judge and others to have these tools in their toolbox, because each child is an individual. I have 5 children. I'm sure probably most of the people in this room have children, and everybody knows you cannot parent your children exactly the same way. And so in my book, this amendment provides a tool in the toolbox to allow these children to actually have more time to take corrective action and to change their lives and to prepare for the adult world. And so because of that, I think this amendment is a good one.
All right, thank you. Representative Heiberger.
I appreciate that, and I appreciate the amendment too, but I guess what we're looking at is a detention limit. And I think all the evidence we saw during the 367 process was that long detention not only doesn't produce better outcomes, it produces worse outcomes. And my fear is that if we start ratcheting back, and we put this tool back in the toolbox, it's going to be used not just for the kids who need it, but for the kids who don't. And they will start getting more of the adverse outcomes that we're seeing before. That's my concern. So I understand, I know this is brought in good faith and with a good basis, but I'm going to have to oppose it.
All right. Representative Howell.
I just want to double check my understanding with Natalie. This is we're allowing an extension so that they can finish evidence-based treatment, correct? I mean, is that part of that? Or am I jumbling things?
And you can't bring my candy to committee either. Go ahead, Natalie.
Representative Owens and Representative Howell. So the extension, the overall case length limit extension is in the underlying bill. The amendment that you're talking about right now would allow for an increase in the cumulative detention limit. So right now, over the course of a juvenile's entire case, they can only be sanctioned to detention for 45 days. So say they're in detention for 5 days at the very beginning, and then they kind of mess up on probation, they get sent back to detention for 5 days. That's 10 days toward that 45-day limit. There is no cumulative detention limit for the very serious offenders already. So if they commit an off-grid or a severity level 1 through 4, the 45-day limit doesn't apply to them. The judge can put them in detention for as long as they want. But for those lower level offenders, right now, the judge can only sentence them to detention for up to 45 days. And this would change that to 90.
Thank you for clarifying.
Great questions. Great conversation. Anything else, committee?
Yes, Mr. Chairman, I'm sorry.
Go right ahead.
Thank you. Following up on, I believe it's Representative Howerton's question and the reviser's answer. For these lower level, if you will, juvenile offenses, we talk about the time of detention for the case. And is that the same thing as saying for the juvenile's lifetime? If the district attorney or the prosecutor files a case because there was I don't know, whatever the offense was last week, and then the prosecutor files a different case next week because of a different form of bad conduct, or even if instead of revoking probation, parole, whatever, because of a subsequent act, which if committed by a person of age would be a crime, can the prosecutor file a new case and therefore keep people in custody for more than just the case limit on these comparatively minor but important offenses?
Mr. Chairman, Representative Carmichael, this is per case. So say, for example, a juvenile has one case that they've already been adjudicated, which we call, that's convicted in the adult world. They've already been adjudicated. The case has been disposed of, so they have their sentence, and say they're on probation for that specific case. Then the judge would have 45 days to be able to sanction them to detention. Now, if they go out and commit a new offense, a new felony offense, then they would have a new 45-day cumulative detention limit for that case.
And just if I may, Mr. Chairman, to follow up, I know one of Deputy Chief Saucedo's real concerns was the repetitive car vandal. The kid who goes down the street thinks it's fun to break car windows every Saturday night, and has expressed his concern that we just bounce him in and out and doesn't do any good. But if the prosecutor charges multiple different instances of vandalism, criminal damage to property, whatever, can the judge stack them up, as we would say in some contexts, run it consecutively?
Mr. Chairman, I want to make sure we're kind of talking about the use of this detention properly. So if the juvenile is on probation, say the juvenile is on probation for some type of an offense, and they go out and commit, they engage in that type of behavior, then the court services officer who is responsible for supervising the offender on that probation, they would have the opportunity to engage those graduated community-based responses to violations of probation. Now, if the district attorney files new charges because of that conduct, then we're talking about a whole new case. And so all these things, the overall case length limit's going to start over. They could get probation again. So that probation length limit for this new case would start over, and as would the cumulative detention limit. And I would remind you too that in order to place a juvenile in detention, they do have to score detention eligible on the detention risk assessment.
Mr. Chairman, I really appreciate what the revisor has shared with us, because it's helped me clarify that sometimes the complaints that I hear from my friends in law enforcement may well be because the prosecutor, for whatever reason, elects not to file new charges against people who commit comparatively minor offenses while on probation, if you will, for an earlier offense. And if that's the reason we have this situation, then we don't need this law. We need the county attorneys and the district attorneys to listen to law enforcement and perhaps take a different attitude toward their charging decisions. Thank you, Mr. Chairman.
Certainly. Natalie, do you have a follow-up?
Well, so Mr. Chairman, I just wanted to point out that while I was kind of looking at some of these statutes to answer some of these questions, I did note that KSA 38-2361 actually has another reference to that 45-day cumulative detention limit. So if this amendment were to be adopted, I would just ask for leave to make the change in that coordinating statute so that they would match.
Certainly. Thank you. All right, committee, any additional questions on comments on this amendment?
Mr. Chair.
Go ahead.
One of the things, and I've tried to figure out a way to put this in a way that's brief, and bear with me just a moment, but we talk about these offenders as if all they're doing is vandalism and these type of things out there. I have a case running through my head right now recently, and recently being within the last 5 years, where I dealt with a 17-year-old that I make him show me ID because I didn't believe he was under 18. I mean, he's a pretty good sized kid. He's also a good kid. He is, but he got involved in some things, and it involved armed robbery inside a person's home, where they held the individual up and took money and anything else they could find, while they were really there just to sell drugs. So the individual is actually with an adult. They spend time in the home. As they're going out the door, gunfire is exchanged. Now, this is out in rural Kansas, out in little old Lebo, Kansas, where this happens, and people don't think those things happen there, but they do. So here we are, we're dealing with this individual, and he's very polite to me. He does, I mean, I couldn't ask more of him to be respectful. You have high hopes for him, but the situation is simply that he doesn't have a whole lot of guidance when he gets out of detention. Of course, he's detained for a short time, and he gets involved in another very serious action. And I'm not going to get into details because I don't want it Googled and figured out and all that kind of thing. It's not fair to him. My point being that sometimes the circumstances are not simple. They're not a 45-day fix. And so I would support this simply based on because it's not going to happen regularly. This is not something that we expect kids are going to be held for 90 days on a regular basis. But there are outlying circumstances out there where we need to be able to give our system the chance to deal with these and not rush them off the table. And that's the only thing I'm concerned about. Opening this up a little bit is what we're doing here to allow for that kind of adjudication to happen. I needed to get that out there. Thank you.
Thank you. Representative Carmichael.
Thank you. Following up with what my friend Representative Smith points out, and I don't think any of us here want to see violent people who would be known as felons were they of age getting a break out of this deal. But I think what this part of the statutory scheme is directed to is the lower level crimes that juveniles might commit. And I think, and I don't want to speak for my friend Representative of the Vice Chair, but I think the situation you are describing is the juvenile who commits a comparatively minor offense, gets released from whatever we call it at 45 days, and then goes out and shoots somebody. And so I'm not sure we're talking about the same folks here, but I'd really appreciate the expertise of the Vice Chair because he's been there in the dark of night and I haven't.
Thank you, Mr. Chair, and thank you for correcting me on that. You are correct. It would not apply to the story that I gave. Thank you.
All right, I feel like I've asked this about 20 times, but is there anybody else? I'm grateful for the conversation, though. This is what working a bill is supposed to be like. We're supposed to have conversation. We're supposed to bring up our thoughts and our concerns, so I'm grateful for this. If there are no other comments, then we'll let Representative Howerton close.
I close.
Thank you. Committee members, all in favor of this amendment say aye. Aye. All opposed say no.
No.
The ayes appear to have it. The ayes do have it. Representative Heiberger is a no, and Representative Carmichael is a
not voting. Thank you.
All right, there you go.
I defer to the wisdom of the committee.
Very good. I do know of one other amendment out there. Representative Howell, if you would like to share, while that's being disseminated, go ahead and share what your amendment does.
Yes. I believe my amendment is on page 9, under section 7, looking at paragraph 4. This basically, after listening to testimony when we had our hearing, this again provides some options that the judge may choose to use if he or she feels necessary, and this just provides a way for if we have a juvenile who's having a disruption or those types of things while in court and that type of nature, this gives them some reasonable consequences that help prepare them for the adult world, but yet are still within reasoned and graduated increments.
All right. Thank you, committees. Everybody had a chance to receive that in their inbox at this point? Okay. Representative Heiberger.
Mr. Chair, my computer battery died because of our extended time on the floor, so I don't have my computer, but could we have Natalie explain the amendment, please?
Natalie, you want to share what this amendment does?
Because I'm looking on page 9 and I don't see where this fits.
Thank you, Mr. Chairman. So essentially what this amendment would do, currently, if a juvenile is violating their, it's adding a new section. So we're making changes to KSA 382392. So we would add that as a new section 7. So the bulk of the amendments on the last page, you'll see the attachment there, the changes that are proposed to be made to that section. So under current law, if a juvenile is on probation and they violate that probation, there's a set of graduated community-based responses to that probation violation. And so you'll see those in subsection B there. What this would do would be provide that when the juvenile's on probation, a judge would be able to commit the juvenile to detention for a violation of probation, including a technical violation of probation or for contempt of court. And then it would place caps on the detention period. So for a first violation, they would be able to be sent to detention for 24 hours. For a second violation, up to 48 hours. And for a third or subsequent violation, it would allow them to be sent for 15 days.
Questions of the revisor? Representative Rissman.
Thank you, Mr. Chair. I wasn't here the day of this hearing, so I have a question. Didn't we pass something last year, the year before, that allows for a quick dip or dunk into jail? Or is that?
Not in the juvenile system that I recall, but Natalie?
So we do the phrasing that you use there, the quick dips and the dunks, that's something that we do for adults for probation violations. So their court services officers have the ability to dip the offender for 2 or 3 days in county jail. Juveniles aren't allowed to be dipped like that into detention. They would have to be scored detention eligible before they could go to detention. And in fact, for technical violations of probation, they wouldn't be able to be sent to detention at all under the current law.
Okay, all right, thank you. Something just struck me when I heard that, so.
No problem. Thank you. Representative Heiberger.
Question for the maker, if I may?
Sure.
I'm just curious about how this amendment was developed. You work with people in the field, or is it modeled from something another state does?
So sorry. Thank you, Chair. Thank you. Just from listening to testimony, and I have spoken with at least one judge friend on this topic and just some others in the community. And again, I feel like this is a balanced approach to help still treat them as a juvenile, but yet also trying to help prepare them for the future.
Representative Carmichael.
Thank you, Mr. Chairman. Couple of things. Let's start out with, I hope someone, whether it's the revisor, who is definitely earning her pay today, and we've still got judiciary yet to do, but I need to find out what some examples of what's meant by a technical violation and even a scope of what fits within a technical violation as opposed to I can't remember, whatever you call a more severe violation. So can someone help me understand examples of the type of conduct that we're talking about here when we say technical violation?
Mr. Chairman, if you give me just 1 second, I want to look something up real quick.
All right, while she's looking that up, Natalie, again, watching out for me, realized that I never got a second on this motion. So can I get a second on this? All right, thank you. Representative Smith will be our second. Representative Heiberger.
Yeah, I just want to say that I'm intrigued by the idea. I think I might be able to support it. But what I'd really love to hear more is from people working in the field to see how it would impact what they're doing. And I guess I'd be a lot more likely to support it if we hadn't just extended the detention limit to 90 days. But
Go ahead, Natalie.
Thank you, Mr. Chairman. So a technical violation is defined in the code. It's in KSA 382302. That's the general definition section for the Juvenile Justice Code. And it means an act that violates the terms or conditions imposed as part of probation disposition, and that does not constitute a new juvenile offense or a new child in need of care violation.
Got it. That makes perfect sense. Thank you. We're not talking necessarily then about criminal conduct or conduct that if charged against an adult would be described as criminal. It can be lesser violations. So here's where I'm at on the amendment. Might be a good idea, but I'd want to hear testimony from experts in the field, people who deal with this situation, to try to explain to me not only whether this is a good idea or a bad idea, but how it would work and what the collateral consequences, both good and bad, might be. So I'm probably going to vote no on this amendment, but that doesn't mean that I oppose the idea, and I hate to entrust anything to our good friends in the Senate, But should this bill make it across the floor and arrive in the Senate, I certainly hope that my good friend, the chair of Senate Judiciary, would arrange for some good testimony to, no matter whether this is in the bill or not in the bill, from experts to try and help us all understand the consequences of this. So for the time being, I'm going to have to be a no on the amendment. Thank you, Mr. Chair.
Thank you, Representative. Any other questions or comments on the amendment? All right, seeing none, Representative Howell, you may close.
I close my amendment.
Thank you. Members, all members in favor of passing the amendment as mentioned, say aye. Aye. All opposed by the same?
Aye. No.
No. Okay. We have one abstaining, and Representative Carmichael is a no. But the amendment does pass. I should say that. All right, are there other amendments on this bill? Or is there additional discussion on this bill? Can Natalie remind me who made the motion on this bill? Because I forgot. Yes, you may.
Well, I also have concerns about the part of the bill that extends the use of the money from the fund. I mean, we've really fought hard to protect that money, and I understand how it could be useful to use it for kids before they get into the system, but I guess I feel we need to protect the money we've got to work with the kids in the system, and that money to work with the kids before they're in the system needs to come from the general fund or somewhere else. So that's another reason that I will oppose the bill.
Anyone else? Representative Carmichael.
I concur with the ranking member. Thank you.
Duly noted. Who was the maker of my motion? Have I not made one yet? No, I don't know, obviously, Natalie. I'm still learning all of this. Okay, that's right. I sure wish my other committees did it the way that we've always done it here, because that would be a whole lot easier. Yeah, I know, and we may do that going forward. It's kind of like you finding your own rhythm and your own groove in the chair. So, okay, committee. Do I have a motion as it pertains to House Bill 2200? Representative Smith.
Mr. Chair, I move HB 2200 as amended be passed favorably out of committee.
All right, thank you. Do I have a second? Representative Howerton, second. All right, now is there any additional discussion? All right, seeing none, you may close.
I close.
All right, thank you. Committee, all members in favor of passing House Bill 2200, say aye. Aye. All opposed, nay.
Nay.
All right, the ayes have it, and we have Representative Heiberger and Representative Carmichael as noes. All right, committee, that concludes our work for today. We have a little bit of work tomorrow, but next week certainly going to be very full, as you guys heard all the bill introductions from Monday. Is there anything else needs brought before the committee before we adjourn?
Yes, Mr. Chairman.
Representative Carmichael.
Last harassment of the day, Mr. Chairman.
Oh, hold on. Does that apply to judiciary as well?
No, it does not, Mr.
Oh,
Chairman.
okay. Just checking.
I commend to you the way the second chair that I served under in judiciary handled these bills. By the time you got the folder or the bill file out of your folder, the motion had been made and the bill had already passed out of committee. And so that's the way you get it through, my friend. Just, move right on through. But I really do appreciate the way the committee's operating, and thank you.
Very good. Thank you. All right, committee, with that, on that great positive.